And it's even possible to go back to prison for a longer period of time than initially served for the offense itself. Hello again, this is Lana Manitta with Rossen Law Firm, and today I'm going to talk to you about supervised release in federal criminal cases. Before we get started, remember to like and comment on this video and subscribe to our channel. We post videos providing education on a wide variety of issues arising in criminal defense. So, supervised release in a federal criminal case is a period of supervision after a defendant has served some period of incarceration. Put simply, it differs from probation in that probation is an alternative to imprisonment and supervised release comes after imprisonment. But they're very similar and they're governed by the same office, the probation office. Now, when and how or how much probation or supervised release a judge can impose has its own statutory provisions and complexities, and that I'm not going to get into in this video, but for purposes of understanding the two in practical terms, that's the basic difference. One is an alternative and one is after incarceration. So both of them, as I said, are governed by the probation office. You're supervised by a probation officer, and a violation of either constitutes a distinct offense aside from the underlying offense and can be punished accordingly. So it's important to know that just because somebody gets a probation sentence or a short incarceration sentence followed by supervised release, that does not mean that that person has avoided prison for all time on that case. A violation of probation or of supervised release can cause a defendant to go back to prison. And it's even possible to go back to prison for a longer period of time than initially served for the offense itself. Because somebody can be sentenced to serve a period equal to the term of supervised release if they violate it, regardless of when that violation occurs. So, for instance, if you get a 5-year supervised release term and violate it in year 5, you can actually still face up to 5 years for that violation. Now, the reality that happens in federal court is that the individual is really going to be sentenced based on a set of guidelines that apply specifically to supervised release violations. And these are even less binding or more advisory, depending how you want to look at it, than the regular sentencing guidelines. The federal sentencing guidelines are advisory, which means the court is not bound by them. But there is a separate set of guidelines that applies to supervised release violations that have even less authority. That they're really policy statements. So even less authority than the guidelines themselves. So by and large, judges do look at them, but there is much more variance on sentencing in supervised release than there even is in regular sentencing using the regular sentencing guidelines. So receiving a sentence for a violation of supervised release, that is the max time, which is, again, the entire term of supervised release, that's not very common. It's very unlikely, but that is the exposure. And so it is really, really important that when you are on supervised release or probation, for that matter, you're meeting every condition to the letter. And a good federal defense attorney should be going over these conditions with you prior to any plea so that you know this is a consequence of what you're going to be doing. And they're not laid out in your plea agreement. And also, again, prior to sentencing. Now, your pre-sentence report will include a list of conditions that are going to be recommended either for probation or for supervised release. And these need to be reviewed and they need to be addressed at sentencing. If there's any objection or an alternative recommendation to be made, it really should be made at sentencing and not dealt with after these conditions are already in place. These conditions, should be available to you to refer to whenever you need them. So while you're serving your sentence or while you're on supervision, it's really good to keep a copy of the conditions. Your probation officer or your supervising probation officer is going to give them to you, but keep them handy because some of them are easy to forget. And if they're easy to forget, they're easy to violate. And a violation is not something that you want to deal with. It's something that you want to prevent. And so a good federal criminal defense attorney will also be available to you while you're on supervision. You should be able to reach out to your counsel not once there's a problem and it may be irreparable, but as soon as you're having a problem with your compliance to conditions. Are you having trouble getting to the classes that you've been told to take? Are you having trouble finding a job and you have a condition that you have to be employed? Are you having a problem staying off drugs? You should be able to talk to your attorney before you fail to show up or before you test positive. And in that way, counsel may be able to head it off at the pass, seek a modification of your conditions, talk with your probation officer, find a way to work through the problem, maybe get increased drug treatment before you're facing a violation, because a violation is potential prison time. So what's also important is maintaining a really good relationship with the probation officer. That's the key to success. Meeting the conditions and having a good relationship for when you can't meet those conditions. Now, that doesn't mean you're friends. This person is supervising you, and their job is to report when you violate. They work for the judge. So the probation officer's job is not to be your friend and to support you whenever you're failing, but to eventually report you to the judge and let the judge know this person is not meeting the conditions that you've set for their, staying on release. But this person makes recommendations to the judge as to what should be done and when. And so if you are communicating often and effectively and honestly with your probation officer, you're not dodging her, you're not keeping things from her, you're not lying to her, you're going to be in much better shape even if you do have a violation. The worst thing you can do on supervised release or probation for that matter is disappear, fail to report, fail to keep in touch. And a lot of times people will do this because they're afraid of another kind of violation. They're afraid they're going to test positive, so they don't show up for the drug test. They lost their job, so they don't show up for the monthly meeting or submit their monthly report. Or worse, they've had contact with law enforcement and they don't want to tell their probation officer, so they don't show up. Well, now they're violating two conditions, right? One of them is to stay in touch and report regularly and be truthful. And there's always a condition to report any contact with law enforcement within 72 hours. So by, getting scared and not showing up or not calling in because you don't want to tell them you got a speeding ticket, you're actually committing two separate violations. And so, it's, again, really important to know your conditions, have your attorney who you can reach out to and ask questions, and stay in touch and communicate openly and honestly with your probation officer. Because not doing that, not keeping in touch there's 100% chance that you're going to get a violation. A petition is going to be filed. It's going to be in front of the judge. And, these are issues that may have been able to be addressed by modifications to your conditions or just, early and open communication, even if it's necessary to do it through your lawyer. And you don't have to navigate this. You don't have to navigate this on your own. If your original attorney that represented you in the underlying offense isn't helping you or doesn't want to work with you with regard to supervised release for any reason, you should seek representation, a new attorney who can at least be on call until your supervision period is over. Because when a violation is filed, not only does a whole new process begin, but it is accelerated, meaning it's much faster. than it was with the underlying case. There's going to be a new probable cause hearing. There's going to be a new detention hearing, and there's going to be an evidentiary hearing at which the district judge is going to decide whether you're in violation and sentence you on that violation, all within a very condensed period of time, maybe a week or two. So this is really just an introduction that I've given you to what supervised release is, as opposed to probation, and the similarities and the differences. It is a hot topic in federal criminal defense because most people will face one or the other if they are currently facing federal criminal charges. It's very unlikely, if you've been indicted on federal criminal charges, that you are not at least going to be on probation or have some supervised release after some short period of incarceration. So there's always much more that I could say on this topic. As I say in every video, there's always much more I could say. But why don't you let us know by commenting on this video what other topics would be helpful or interesting to you within the area of federal criminal defense or state criminal defense, especially as it relates to South Florida. And if someone you know is facing criminal charges in federal court or the state courts of South Florida, please contact us at Rossen Law Firm today. And as always, thank you for watching.